Let's call this meeting of the Eugene Planning Commission on December 10th to order. First item on the agenda is public comment. I have one person who has requested to speak. If there's anybody else that would like to speak to the commission on an item that isn't either hasn't had a hearing or isn't docketed, please fill out one of these green slips. Other than that, Lisa Warnes, if you would please take the chair.
Hello, Lisa Warnes, Southeast Eugene. Thank you for arranging this in a more friendly, audience-friendly manner. I don't really have an agenda item I want to talk about today. Mostly in general planning, my concerns are around climate change and knowing that the way we plan our drainage systems and calculations around drainage, we factor in 100-year events. And as far as I can tell, I think we've had 2 of them within the last couple of weeks. And I think that we're going to have wetter winters. And when you get an accumulation of 8 to 12 inches overnight, that's something that really concerns me in terms of how are we going to look at, is this even a conversation in the city planning department? And since I know there are city planners here, their ears are here, I'm just kind of want to start that conversation. So that's really all I had to say today. So thank you.
Thank you. Thanks. Anyone else care to address the Planning Commission? Okay, with that then we'll move on to agenda item 2, the Deerbrook PUD appeal deliberations and possible action. This is agenda item, or city item PDT 12-1. Our objective today is try to bring closure to this matter. At our last meeting last Monday, our marathon session, we made a considerable amount of progress on the appeal issues. There are still 3 or 4 that we agreed to circle back upon. But also became evident during that discussion that we had that there were 2 issues raised that are central to our deliberations and decision making. And one has to do with the extent to which the hearings official applied the PUD criteria to the entire 72 lots proposal versus just the 47 lot alternative. And then the other issue has to deal with the degree to which conditioning might change this application. And Bill and I talked with the staff and agreed that we probably ought to have that discussion right up front to kind of set the stage for circling back to the other specific issues. So with that, let me turn it over to Gabe, Steve, Emily. Steve?
I just want to register something that we did deal with that I'd like to come back and revisit is on page 13, and it's essentially the map that we're using to determine slopes, and we're accepting as the official map.
At page 13, Steve, just to clarify, it's not PC, is it the same as PC agenda page 16?
Yeah, sorry, PC agenda page.
Well, just to be clear, okay.
Yeah,
sorry.
It would be the first bulleted item, and wherever that's mentioned, it's just, from my point of view, I think we should reevaluate which map that we use. I think we should be using the 75 lot map in all of our discussions, not the 47.
Okay, well, let's have that discussion.
Yeah.
All right, anything else from commissioners? Okay, Steve?
Thanks. So as was mentioned, we're following up from the last meeting with the progress that you made. Covered a lot of territory and got a certain level of direction from you from that meeting. And so with that, we've drafted a final order for you to consider today, recognizing that there are still some unresolved points that Commissioner Luddick mentioned that we'll want to touch on. So we'll want to walk through that today. What we tried to do was to actually physically highlight for you in the staff report or in the draft final order where those areas are that we'll want to focus on. Those represent either areas we didn't really tackle yet or areas where there are some key decision points that need to be made today, normally along those 2 questions that were raised in our AIS. And so that's just kind of, I think, the roadmap that we'll want to use today. If I can, just real quickly on the 2 items that Commissioner Luddick mentioned, the first dealing with the questions that arose around whether or not the hearings officials' findings were addressing 75-lot proposal or the later 47-lot version that emerged, and there was some confusion around what his findings were relating to. We've gone back and assessed that, and in short, what we're concluding is that the hearings official stopped short of evaluating all the applicable criteria once he found noncompliance with the slope provision. In essence, that alone had the impact of eliminating the eastern portion of the site. He chose not to evaluate other criteria, concluding, I believe, that the project and the eastern portion was already, in essence, eliminated. We went back and have now supplemented the findings to address the question of compliance or not with those other criteria. And long story short, there's at least what I think 3 additional areas that we've identified where the project, the 75-lot project, did not comply with the applicable criteria for the eastern portion of the site. So in essence, what that means is that there are several reasons, in essence, that are noted in the final draft that would negate the ability to build on that eastern portion, not just slope. We can talk about those as we get to them if we need to. The second area deals more with, I think, a lot of the conversation that we had and maybe the concern that some of the commissioners expressed around the just the evolution and change that occurred from the original submittal to the 47-lot version, both in terms of process and in the actual physical content of that design and what it looked like. And we thought it would be helpful just to walk you through a little bit of that history, just so everybody's on the same page about what happened, what didn't happen, and what that net effect is. And so if I can, I'll have Gabe just walk you through a little bit of the chronology of that history so that at least we have that as a backdrop before we get going. So Gabe, do you want to?
So, yeah, to start, we thought it would be helpful for you all to see a comparison of the 2 plans. On the left is the original 75-lot plan that the applicant submitted, and on the right is what we refer to as the 47-lot illustrative plan, which came into the process later on. When the applicant first submitted the application with 75 lots under the needed housing criteria, staff reached out to both the applicant and the neighborhood representatives in an attempt to try to find some common ground and look at perhaps a more collaborative approach than typical to bringing the parties together and look at solutions and whether or not there could be a win-win outcome. At that time, the planning director actually wrote a letter to the applicants about this interest in taking a collaborative approach. Staff then held a series of meetings with both the parties to try to get a better understanding of what those concerns were. We heard from the neighborhood that one of their primary concerns was development on the eastern portion of the site, as well as one of, I think, their paramount concerns around protection of the Amazon headwaters. We also heard at that time from utility providers and from public works staff about concerns related to the utilities that would be needed in the eastern portion of the site, and those would extend north from the development area through city parkland to Canyon Drive. We found at that time that there were essentially 2 key areas of noncompliance. One was that the development shown on the eastern portion of the site was within an area that we had evaluated as having 20% slopes or greater, a large portion of that. Also, we found noncompliance with stormwater standards and criteria that require the provision of key urban services and facilities. So we were uncertain as to how they could comply and found that they didn't have adequate evidence to show that they'd meet the standards at that time. And so, preceding the initial public hearing, we recommended denial of the application. Yeah, Steve?
Well, before we get too far, I want to make sure that we're not, we've been very rigid about not introducing new evidence. So unless this letter is in the record from
it is.
the planning director and these conversations, and this is written in the hearings record, I think we have to be very careful.
I might have it right here, Steve, the letter from the planning director.
Yeah, no, but I mean the other discussions about the details, too. In other words, we've been very
Great.
on your suggestion.
I mean, you're familiar with the record. So far, everything he said is certainly proved up in the record.
Right. And we've accounted for that in some of the initial staff
I want to make
reports.
sure that we're covered, that's all.
Yeah,
I appreciate
it.
Well, I'll back up a little bit here and note that there are some key differences between these two plans. You know, on the left, you'll see the 75-lot plan there. On the right is the 47-lot illustrative plan. The biggest difference is that it eliminates development from the eastern portion of the site. There are some other smaller differences where lots were reconfigured or street alignments tweaked a little bit, and I could point those out in more detail if needed. But really, I think the point is that the layout of the western portion of the site is virtually identical. It's very consistent with what was originally shown. The main difference being that development's eliminated from the eastern portion of the site. In our initial staff report, we recommended denial based on the slope provisions as well as some other criteria related to stormwater and key urban services. When the applicants received the staff report, they were very concerned about moving forward with a recommendation for denial, and they decided at that point to postpone the public hearing and attempt to address the concerns that were raised in the staff report. And what they came back with was essentially the 47-lot illustrative plan. At that time, we renoticed the application with the illustrative plan provided so that all the parties would be fully aware of the change and would be able to address that change as part of the public hearing. During the public hearing process, there was a variety of evidence submitted, and one of the pieces of evidence there was what we've referred to as the Matthews map, which showed a largely consistent measurement of slopes on the site, but it had a few additional areas of 20% slope that weren't shown on either the staff analysis or on the 47-lot plan, which is essentially the applicant's attempt to show the sloped areas as mapped by staff. So the hearings official basically denied the application for lack of compliance with the slope criterion. He had relied on the Matthews map for that finding. As Steve mentioned, he did find other reasons for denial, but he was only addressing it based on the 47-lot plan from that point forward in his decision. We've attempted to address that in the final order at this point. But I think today, in the interest of making sure that we're all on the same page moving forward, we're going to recommend that the Commission start with its discussion of a revised condition that we've embedded in the final order. This is under Appeal Issue 1. It's Subassignment 2C. It's actually on page 16 of the agenda packet. And we've attempted to revise the condition to be absolutely clear as to the effect of it, that it removes or eliminates development on the western portion of the site. And so before we get to the other issues that we didn't fully address at the last meeting, we'd hope that you'd begin with some consideration of that issue and the revised condition to see where the Commission's at on the slope question and make sure we're all in agreement about what we're evaluating.
And that's on page 16 of the PC agenda. It's the bulleted item, Gabe?
Yes.
Okay. Steve?
Yeah, this speaks directly to my concerns. From my point of view, we should be evaluating throughout this process the 75-lot plan and decide, because that's what the hearings official made his decisions on, and we should be evaluating the 75-lot plan. And if in this case the 75-lot plan does not meet the slope criteria, then we have to agree with the hearings official. Now, later on, if we decide we want to make all kinds of modifications to somehow make this thing comply, that's something else. But in terms of, from my point of view, we should be evaluating what was proposed by the applicant in the application, which is a 75-lot plan, and what was reviewed by the hearings official, which was, he rejected it because the 75-lot plan didn't comply with the slopes. because I kept reading this and I kept getting confused. It's like a shell game. If you keep dropping that out, then all of a sudden, okay, now it meets the 20% slope criteria. But that's really not the question. The question is, what was the application for? The application was for the site plan on the left. Any time during the process, the applicant could have reversed the process, stopped it, issued, it would obviously cost some money and it'd been more time, but they could have submitted a new application for the substantially revised plan, which turns out to be about, 60% or 63 or 4% of the size of the other one. So from my point of view, that's what's confusing about this, both here on page 16 and the same thing on page 21. Wherever we're looking at evaluating a 47-lot plan, we should be evaluating a 75-lot plan for consistency. That's what was, that's my perspective.
No, and I appreciate that. And when you and others brought that up at the last meeting, there was a point where I had some confusion in my mind about the solar lot standards and how that applied to the 75 lot and so forth. I think staff heard that loud and clear, though, and as I heard Steve say, in at least the unresolved issues and back on 2C now, they've gone back, and because we're taking a different approach than the hearings official did using the Matthews map and we're not, I think that gives us the ability to go back and take a re-look and reapply the criteria, which is what staff has done in some of these other instances, as I understand it. And I don't know, do you want to address conditioning and how that all...
A couple of things. I think that's right. At the end of the meeting, the concern that you expressed about taking, when we kind of think about the comments that you brought up and others agreed with, it was looking at each criterion that is implicated by the appeal as if it's the first criterion we're looking at. And so looking at it based on the 75-lot application as if that was the first, nothing had dropped off from any previous criterion review. And staff has done that throughout this document. If there are places where you think that it's not done, I think we need to talk about it because there was a very intentional approach to respond to that concern. That said, I want to go back to that discussion as well. When you began talking about conditions at the last meeting, I referenced a statute that I want to come back to. But the big picture approach here that you need to remember with every single application you ever look at, with respect to each criterion, you have three options. The hearings official has three options. The first is you determine that the criterion's been met by the application. You make that analysis, you move on to the next one. Or you determine that the application doesn't meet the criterion. And you can address that inconsistency of one of two ways. You can either decide it doesn't meet it, we're denying, or you can craft a condition or look at a condition that's been proposed to you by someone and see, well, okay, can we condition approval so that it renders their development proposal consistent with the application. And in some cases that means lots drop-offs. In some cases it might mean a street moves. And you basically apply a condition that would render the development plan consistent, and then you move on to the next one. Now, I mentioned you can deny. And when we got to the point in that discussion last Monday, I referenced a statute that specifically says if a city can impose a reasonable condition, instead of denying, it has to do so. And told you I'd come back to you and talk to you a little bit more about what that statute means. Turns out, LUBA has interpreted that statute as being totally inapplicable in this instance. Because when the Home Builders Association got that piece of legislation into the statutes, it was under a broader heading called moratoria. LUBA decided it only applies in the context of moratoria, which is pretty much never. So we're back to the law that preceded that statute. As far as I'm concerned in this case, the Court of Appeals could decide differently, but we're going with what LUBA said, and that is that you don't have an obligation to impose conditions, even if they're very reasonable. You could deny. Having said that, I know that this body rarely goes that way. We're most often instructed to proposed conditions and try to get to something that you can approve. So what you have here provides both those options. It is written such that if you want to impose a reasonable condition, staff have identified them, the applicant actually, I mean, they've been in the mix since the 47 lot illustration came to play. You can do that. Staff believe that's defensible. If you want to just straight up deny, we could defend that too.
Other questions, comments, John?
Yeah, just to make me feel, let's say, more comfortable on the 75-47. I believe, Gabe, you indicated that you had these discussions and then went out with a renotice that included the 47 lot, I'll call it illustration. Okay, so that went out to the public. Is that correct? And there was
Yes.
a period of time for them to respond to that?
Yes.
Okay. My question is that typically done, or is this like a precedent-setting thing that you have done? In other words, on other proposals, have you sent out revised plans or illustrations and considered them as with the application?
I wouldn't exactly call it typical or ideal, but it's certainly something that the city does do in the event of an applicant's request to postpone, and if they're in effect submitting a revised plan or something substantially different that wasn't in the initial notice, we make sure that all the parties have that notice well in advance of the hearing and that they'll all be able to participate and comment on it as part of the public hearing. So that was one of the...
But that revised plan is not a new application. Does it have to go through a completion review also?
It does not. And
So why wouldn't every developer do that then? Submit something and then just keep submitting different things and not have to go through the process of completion review on what was an initial application?
Well, I can't really speak for the applicant, but I do believe they were reacting to a recommendation for denial, and so they decided that they would put the hearing on hold in order to try to address those concerns.
I can tell you from a legal standpoint, I don't have a problem. I mean, that second notice eliminated a legal issue. If a new notice hadn't gone out, and we do, anytime there's a hearing that's been canceled and rescheduled, we send a second notice. Does it always show changes to the proposal, or does it always sort of update where the proposal's been? Probably not. But from a legal standpoint, it basically puts the city back on good legal standing because that notice preceded the hearing. So the 47 lot illustration was available for as long as an application normally would be. And so
While we may have preferred that they withdraw and start over, we didn't have the code authority to require that. And so in this case, we felt it was the best possible outcome in terms of due process based on their intent to move forward and not backslide on the process.
So in a process like that, you consider both, or do you just consider the revised plan? That's where I got confused, because when I look at this as we go through it, I see conditions being put in reaction to the 75 that seem to suggest the 47 will do, and then you look at the 47 and there's conditions related to the 47.
there's not, actually.
The 47 is totally clean as submitted.
The 47, and that, I think you're getting to the problem that we grappled with. When the applicant wanted to proceed this way, you'll see the staff's reaction was to, I mean, as Gabe said, staff lacked the authority to say, nope, you can't do that. What staff did is, well, if you're going to promote the conditions that would result in the 47 lot plan, we want to make sure that we get testimony on that. So they provided the notice. But the applicant's materials are confusing and seem to go a little bit back and forth about how they talk about the 47 lot plan. But, I mean, remember, at its most basic form, 75 lot application comes in. It gets analysis from both staff and neighborhood, and staff report goes out and says, we think you need to deny, and if you didn't deny, you'd at least need all these conditions to make it approvable. Applicant said, yikes, I don't like a staff recommendation for denial. Let's see what it would look like if we played this out, and let's see what these 47 condition, or what these lots, what these conditions would do to our proposal. Staff didn't produce a 47 lot map. They just said, here's conditions that at the very least the hearing official should consider. And the applicant said, I'm going to draw it. We're going to use our experts and have them draw our application to show what would happen if the conditions went into place. And it resulted in this 47 lot design. That's where that came from, right? And so they seemed to present it as an alternative. And in the staff reports, staff refused to consider it as an alternative. The hearings official didn't have a, do we like this one or do we like this one? The hearings official said, you've already said, was required to look at the 75 lot plan. Now, did the hearings official err in not imposing conditions that would have resulted in the 47 lot plan? The hearings official said, we have this Matthews map that makes me question it enough that I'm not comfortable imposing conditions. Makes me question the other contour maps enough. And because I have that question, I don't feel comfortable. What did he say? The apparent problem areas are small areas, but because the applicant did not respond to Mr. Matthews' map or his evidence, the hearings official has no evidence to evaluate whether these problem areas are to be fatal to the overall development. The site plan may very well be able to comply with this criterion or with some minor changes. The current record just doesn't support that conclusion. Staff recommendation is, yes, it does. The staff map is good. You should rely on it.
I've got a couple of people in line here, Steve.
Yeah.
Is that it, Emily?
Yeah.
John?
Well, first of all, give me a little bit of discussion about when you would reject an application and ask them to resubmit. I mean, there's obviously some point in time. Most obviously, it was a different piece of property. Obviously, it's not the same application. But where is that line? Because I'm still stuck with, are we really looking at a different application or not?
I guess I would say there's not a clear, bright line that I could articulate to you that is the trigger. But in this case, obviously, we found, as staff, we found noncompliance with enough criteria that we were recommending denial. We weren't in a position to reject the application, but we were in a position to recommend denial. It would be the decision maker's authority, as in this case with the hearings official, to either approve with conditions, or deny. So it's not about a rejection in that sense.
So it's either complete or it's not. Is that basically what you determine at the completeness review?
Right. So completeness is a process that precedes the formal application and hearing, and as we discussed at length last time, that there were a number of issues of completeness. We identified that it was incomplete, and they ultimately chose to force the application complete and proceed with the application.
So there's no degree of change that would say this application isn't the same that you submitted? At the initial submission versus the point of determination of completion, can they change nearly anything in the application?
I'm not exactly sure what it was that they changed. I'd have to go back and look at the record as to what details were included there. One of the issues was related to the measurement of slope, for example.
I'm mostly referring to the 4775.
The law around this generally goes back to notice. So, I mean, you remember, you have the power to deny. You can just deny, and you can do it for whatever, if you find that the proposal doesn't meet the criteria, you can deny. With that statute out of play, it could be for whatever reasons you think are fair. There are cases where it's become an issue when an applicant made a lot of changes over the period of the application's life, or when the conditions imposed by a governing body make a development so different that folks who showed up at the hearing had no reason to even comment on what it ended up being. And in those cases, there's a procedural error that we think was remedied by the second notice in this case.
Okay. My second part of this question is why the applicant actually submitted two proposals, essentially, in my mind. There's a 47 proposal and there's a 75 proposal. I'd be more comfortable if they said, forget the 75, we're just going for the 47. It creates an ambiguity, which frankly is quite ironic when the applicant is asking for objective standards. He's not giving us an objective proposal, in my opinion. He's given us two proposals and say, which one do you like? Has that happened before?
Nope, and it's against the rules. You can't put two applications in.
But to me, this is appears to be a de facto two applications. One is 75 and one is 47, and he's saying, pick which one I can get.
And we've tried to clarify that point through the findings and through the discussion that that, in fact, was something we didn't accept either. So there was some confusion at the hearing about I think the term was alternative plans, and staff was not supportive of that. In essence, we're back to a 75-lot plan is the proposal. So while there was confusing testimony from the applicant perhaps on that, that's not what's in front of you. You're not being asked to pick.
We've included in the final order language that attempts to make it real clear that the 47-lot plan is best understood as an illustrative plan that the applicant provides to show how the conditions of approval could be met, and that, I mean, in terms of the final order, it's crafted to be clear that this is about a 75-lot application.
My concern is it may be clear now after staff has reviewed and legal counsel has come in and fixed it. My concern is what the neighbors had to look at, which is not clear at all. And I don't think they can give objective testimony given the way the application was submitted.
So, Gabe, is it fair to say that both of these were noticed at one point or another for the neighborhood and any other interested parties? The 75-lot plan was the initial plan that was provided notice, prior to the hearing. The hearing was then suspended, and then the second piece went out to the neighborhood second. So
That's
my
correct.
recollection, and maybe you guys have it here, is the second notice actually said 75-lot subdivision, but there was a copy of the 47-lot. I mean, it was still, both of them were sort of in play.
And I think both is the problem for me. So how do you respond as a neighbor who isn't nearly as sophisticated in Skookum as you folks are?
I think the one potentially saving grace for this applicant if it went forward with a 47-lot is that it is basically a piece of what the original proposal was. And that's,
Well, my concern is we've conditioned this nearly as much as the proposal that we got. I realize this isn't in the testimony, but when we looked at the cell tower application at Oakway, my concern was, again, that we're trying to create criteria for an application which really wasn't submitted. This is analogous to me. We're conditioning this to the point where it doesn't make sense. So I think there are too many conditions.
Steve?
Yeah, I just wanted to go back a couple things just to clarify. Currently, right now, the way what we have in front of us is written, it keeps mentioning 47-lot plan, and that shouldn't really be, again, if we're doing it related to the 75-lot plan, then everything should be, in the text, should be 75-lot plan with lots, 37 to 75 removed. In other words, we shouldn't reference a 47-lot plan if we're not dealing with it, In other words, if we're reviewing the 75-lot plan, all the language should be structured that way. So the condition should be 75-lot plan with lots, 47 through 75 removed from the project. And I want to go back to a couple other things that, and that's throughout the findings here now. I'm going to go back to a point that our legal scholar mentioned here. In some of the wording, when you read from the hearings officials, it's not really clear, for example, that the Matthews map was the sole determinant why he rejected, that it met the, he rejected it because it didn't meet the slope criteria, which we know, right? Because there's a piece here that doesn't meet the slope. Am I correct that this piece on the east does not meet the slope criteria? Is that correct?
That is correct.
Okay, so he rejected it because the wording, because he doesn't qualify his words in a few places when you read that sentence. So it's not clear to me that it was solely the Matthews map that he, if he's evaluating the 75-lot plan and he's rejecting it based on slope, he's also citing that there may be some issues with this Matthews map. It's not clear to me from his wording because he doesn't qualify several times. If you want to read that again, I'm fine. But
well, it's actually a longer passage. It's on the hearings official's decision, pages 13 to 14, and I actually just went back and read it before we met because I wanted to get it fresh in my mind. And, we sort of simplify it by saying he chose the Matthews map. I don't really think he chooses the Matthews map. What he says is he goes through the same kind of discussion you were talking about at the last meeting about skewing triangles, skewing the circle, which is the better way to do it. And, he used computer software, but not mapping or design software such as GIS or CAD, rather than by hand. And he goes through, and it is very much about the doubt that that map has created in his mind. That it shows some fairly insignificant additional areas that Matthew's map asserts would fall within the 20% slope. And says, it seems to me it plants enough doubt in his mind that he doesn't feel comfortable relying on any of the maps. That's my understanding of how he reads it, pages 13 and 14. And I would, it's pretty clear, it's just this entire passage is really about that map. The little piece that I read is the sort of summary, but given all these moving parts and how, after he discusses the Matthews map, given all these moving parts and how one seemingly minor change could result in several downstream changes to the site plan, the hearings official is uncomfortable concluding that this 75-lot application could comply with the criterion with a condition of approval requiring the applicant to make necessary modifications. There are too many design decisions that the applicant must make for the hearings official to envision what the PUD would look like. And the question is, do you agree with that?
Bill?
I guess from my perspective, I know conditions of approval are pretty common, and especially in PUDs. And I guess the way I look at it is, if we started with an application and conditions were such that it made the application approvable, whatever those conditions might be, whether it's lopping off the east portion or other changes, that to me that's a valid way to approach it. To force an and obviously we can deny it and send it back, or send it out, and the applicant could then turn around, reapply, spend the time and the resources, city time and resources, to again evaluate a maybe almost identical plan, depending on how your perspective is. And I guess I'm not sure that's, I don't know, for me, I would rather see if we can craft a way to make it work, make it meet the criteria, if that's something that we feel we can do. And I don't get as hung up on the 75-47 lot aspect of it, because conditions are a normal part of those sorts of things, the PUDs and different applications, and those conditions will necessarily affect some aspect of that application, whether it's the number of lots, the arrangement, or those sorts of things. And so I guess that's my leaning at this point.
Gabe, can you enumerate the differences between what's proposed on the western portion in the 75-lot map and what's proposed on that same western portion on the 47-lot map?
Sure. I have some notes here. The western portion of the site, I'll get up to show you. On the 47-lot version, you'll see there are no lots proposed in this area, whereas we had a short private drive and several lots here. So those were also changed. And obviously, as we've discussed, the eastern portion of the site here is no longer part of the 47-lot plan. The configuration of Daywood Drive was also changed a little bit, as you can see here. And I believe throughout there were 3 lots removed, 3 or 4, and then 2 added back in this tier here and 1 here to I don't know, to make up the difference, I guess, on the part of the applicant. So that's really the crux of it.
Well, it looks like the hammerhead has changed to
Yeah,
the road.
West Morning Drive
Yes.
coming in.
Here. So it no longer crosses, well, it does cross at this location, whereas it didn't in the initial proposal.
And then it's split.
Here.
Yeah,
Right.
yeah.
I think that about does it. In general, we see the configuration, the street layout, and the lot layout as substantially similar.
Can I ask a question of the map?
Sure.
What is the gray area that sort of looks like the flag of a rural mailbox on the right side of the map?
This, as I understand it, is is shading to represent an area that where the city has an exclusive easement for continued public access underneath the BPA lines here.
Okay, thank you.
See, the difference that I'm seeing from your concern, John, is that based on the initial application, the 75 lot, and then on the 47 lot plan that was presented on the re-notification prior to the hearing, this western portion is, we can debate if that's substantial or not, but I think the public had the opportunity to see the same thing on the 47 lot submittal, essentially, that they saw on the 75 lot submittal. The big difference is the elimination of however many lots there are on that eastern portion, and that goes to the conditioning that Bill speaks to. Steve? Oh, wait a minute. Yeah, John.
I just
okay.
wanted to get in the queue. I didn't want to.
Well, if I can respond, I think that the applicant should have resubmitted a 47-lot application, not said this is an illustrative plan to a 75-lot application. I think that would have been much clearer to the public as to what they were responding to. And I think in Goal 1, we have a responsibility to give the public an idea of what it is they're responding to. And I think this created a great amount of confusion.
Steve?
Yeah, I guess I have to disagree with you, Bill, because I've been involved in construction for a long period of time. You do have conditions, but they're usually, and they're common in larger projects, but they're relatively minor. In other words, it wouldn't be that, this would be an exception to lose 30 or 40% of the lots on a project as a condition. It would be, more like you'd reconfigure a few lots, maybe we drop a few here or whatever, maybe some slight road. But if you look at these two, it's like they're two different projects. I mean, it turns out that one of them has a component that's very similar to what the other one had. But, I mean, I don't think we're doing planning, a good job of planning when we use conditions to do planning. We have code to do planning. We have conditions to make minor adjustments to make things work. Because I know my experience is the public is very upset about all these adjustments and conditions and things that get added to projects that, sort of somehow extend the scope and allow things to happen that they don't expect, they didn't think were reasonable. And there's really no way for the public to appeal those, because the way our code is structured, every time you appeal an issue, you've got to appeal it on each separate item. And this would be an example. So I could see how, in this case, if we approved it with condition A, B, C, D, E, and F, the cost to an applicant could be, I got to, appeal condition A, appeal condition B. It's prohibitive for a neighborhood group or a concerned citizen to be able to do that. And, obviously, that's, we're using this mechanism that I just don't think is an appropriate way to do good planning. We have the code to do good planning, and if we make minor modifications, that's fine. But, 74 to 70 or 69 or 80, the roads could change slightly to get the solar lot stuff to work, but we're looking at two different designs. I mean,
I don't hang my hat on the percent change of lots. The applicant came in with the 75 lot proposal based on their interpretation of the 20% slope criteria. We've concluded that they interpreted that incorrectly. And I think we have a pretty good LUBA case telling us that they interpreted that incorrectly. So we've eliminated that eastern portion from the process. Plus, as staff has reinforced on many of the other conditions that we're going to review today, there are other concerns with that eastern portion. So that's out of it. I hear you about the cost for filing these things. That's not within our purview. Certainly it costs an applicant a whole bunch of money as well. So I think that's to be debated in some other forum when it comes down to that.
if I can respond, up until the hearing itself, all of the appeal statements, basically, the applicant was arguing that, should be able to build a 75 because we should be able to use the slope difference between the edges of the property. And, I mean, we can make legal arguments, but anybody advocating that would be considered some, I don't know, certainly not the village intellectual. It's not a reasonable argument that most anyone, now we could argue that from our lawyers can argue that from a legal stand all they want, and the applicant was warned. It wasn't like the applicant wasn't warned that they should be using the 5-foot contours. All along the process, they were told that they should be using the 5-foot contours, and they didn't do it, right? They didn't use those contours, and they insisted on using the edge of the property. So again, and then at the last hour of the hearing, then they finally say, no, we don't want it. We're going to do that. We're willing to accept this now. That doesn't sit very well with me.
Okay. John?
Yeah, just to, and this isn't an illustrative question, just to get an idea here, if we reverse the hearings official's decision, and we're doing that on the 75-foot lot plan with all the 18 conditions, and I'd like to have under number 3 withdrawn any reference to the 47-lot plan, then what happens is the applicant then under final PUD would resubmit something which would look like the 47-lot plan. Is that correct?
Yeah, although I'm not sure exactly how we would accomplish it in the wording. I know 2 of you have expressed concern about referencing the 47-lot plan, but we see it as the most clear illustration of what the effect of the conditions would be. So
I don't think personally, I don't think we need to do that. I think if we say what the conditions are when they come in with the final PUD, the applicant should determine how to address those conditions.
And we could certainly craft it without reference to the 47-lot plan. We'd have to go back and work on the wording a little bit, but yes, I mean, I think the effect of reversing the hearings official's decision and granting a conditional approval with something similar to the condition on page 16 of your packet would result in a final PUD that eliminates the eastern portion of the development.
Yeah, I understand.
Yeah.
But I just don't want to get it confused with reversing the hearings official that we're approving a 47 lot that already meets the conditions we're stating for the most part.
Yeah, I think I understand what John's saying. It's if you go to the bullet statement that says the final PUD plan shall be revised to show the areas of 20% slope and a removal of proposed development from the eastern portion of the site consistent with the 47-lot plan. What we're saying is I think you just need to be more specific geographically or something on what exactly it is. And maybe that's what you were doing, referencing the 47-lot plan.
It was a relatively convenient way to capture all of that with the illustration.
Yeah.
But we can go back and tinker with the wording.
The idea is that based on how we are determining the 20% slope to be objective criteria and how that is to be measured, it eliminates what we all know is the eastern area. It's just that when it gets to LUBA or a future when the final PUD plan might come forward, I see that there's room for maybe some confusion. Okay. I think I'm hearing what John is saying. Yeah. Rick? Or I'm sorry, I had Bill.
Oh, okay, I just have a question on, I think that's a good comment on the 47 lot. I think describing it perhaps geographically rather than in reference to an illustrative map might be a better way to craft that. But I guess my question is, how long before that, when the hearing was postponed, when staff recommended denial, hearing was postponed, and then renoticed, how long before that hearing did the notice, or what was the time frame from the notice to the hearing, and what is normal?
30 days.
Okay.
And that is normal.
And that is normal. So there was just as much notice when it was delayed with the
Correct.
illustrative plan as
The full notice
as
period
there would
on-
have been had it came in that way to start with.
It was a full notice period under the code requirement.
Okay.
Rick?
Yeah, unfortunately, I had to leave a little early last week, but as I left here and went on a fairly extensive drive, I started thinking about this, and I couldn't put my finger on what bothered me about the hearings officer's decision, and it was, I finally realized that to a point the hearing officer was actually talking about the 75 lot plan, and then when he decided that the 20% slope wasn't measured correctly and he took that area out, the document sort of shifted to this concept of 47 lots. And that's when I really realized that I thought that was an error that the hearings officer made by making that shift. I agreed that they should have stayed with the 75. I almost think it's unfortunate that the 47 lot plan even came about after I read through the document, because the applicant was trying to apply for this project. Hearings officer decided, no, you wanted to measure 20% one way. I don't believe that's the right way, and so I'm going to say you can't build that. I wonder where we would be as a planning commission on this had we not had the 47 lot, but we had the hearings officer decision that said, I'm looking at this plan, you measured 20% slope wrong, I'm going to put a no development standard somewhat similar to this condition on page 16, and said you can't build on the 20% slope area. We wouldn't have had the 47. We wouldn't have really even understood what that effect was until sometime long after our hearing went on. So in the kind of the long and short of it, I'm comfortable with the condition, because to me it's just another condition that would be put on any project out there. And I've been around long enough for these that I'm like you, there's a lot of conditions, but that's the way we tend to plan around here. And so I don't want to kind of suggest to this applicant, you don't have the rights to go forward with this application because we think they're too severe. I'm with Bill on this, that let the project move forward, let the applicant make the decision. Do I actually want to build something that fits this other plan over here with all the conditions, and let them make that decision, should I build or shouldn't I build? I do agree with you, John, that I would like to see removal of anything that talks about the 47 plan, because it's real possible that what may come forth after they go back through and do this, it may be a 48 plan or a 46 plan or a 51 plan. Things might be tweaked a little bit. So I'd like to see us get away from that, because I think that just then talks about in our order something that doesn't really exist out there and that we really have no control over, at least I believe we have no control over, to say this is how you're going to make this happen. I would rather go forward than talk about the 75 lots and talk about the way that you condition it. And one of the conditions says the hearings officer decided that this is the way you measure the 20% slope. We agree that that's the way you measure it, and therefore it becomes a condition that anything above that is removed from the development standard.
Any other final comments on this one? I think we're getting down to a point where we need to see a show of hands. So the difference here is, as I read it, the manner in which Condition 3 is being written, and I think there's some discomfort with the way the newly proposed wording is, but the concept of it is to write this such that what we know as the eastern portion of the 75 lot plan is presented is eliminated. I mean, we're trying to satisfy that, make it clear that this is based on our interpretation, the Planning Commission's interpretation of how the 20% slope is measured and identified. Is that, Rick?
Just to be clear, I think the eastern portion is the predominant area, but there are some other areas within the remainder
You're right.
that are affected.
Yes.
So I think it's real important that it's discussed more with regard to slope, how that slope should be measured for whatever modification might occur. And I think it's real important that that be detailed out in the conditions so that there's no argument later on, maybe at Luber or wherever else this might go, how we do the 20%, how it should be measured, and any area that it affects. And it would be all right with me if you wanted to say, as an example, the eastern portion of the site, but there is some other areas that appear to have some slope restrictions. Does that make sense?
Bill?
I have a proposed wording, but I don't know if this is appropriate or not. I don't want to start wordsmithing, but on condition 3, if it were worded something along the lines, let's say, the final PUD plans shall be revised to show the areas of 20% slope and removal of proposed non-complying development, period. Then move to the following restriction shall also be noted. I don't know if that addresses our concerns well enough or not.
I think there may be some value in what Commissioner Leddick suggested, and I think Rick as well. I'd like to think about that a little bit and how best to capture it with the wording, but as I pointed out, there are some areas that the applicant responded to on the illustrative plan by, for example, eliminating one of the private drives and some lots that were in a sloped area. So we could get more geographically specific or even, reference lot numbers and street names that were shown on the original 75 lot plan. But I do think it's important that we're a little more descriptive than that.
So, yeah, Rick?
And just a question back to Gabe. Would it be helpful to, or is it enough having the hearings officers' findings in our discussion to sort of better define the measurement of a 20% slope and the method of doing that?
Yeah, we can specify that as either part of the condition or as an additional condition as well. I think that clarity would be helpful.
Okay, just to circle back at this, the action that we took last week on this condition of approval number 3 was on page 24 of last week's AIS. That's where condition 3 was entered. I guess what I'd like to do is just see a show of hands of those who still want to impose a condition 3, the slope condition, the 20% slope condition, that is modified based on the wording that we've talked about here. I understand we don't have specifics, but the concept would be that this would very specifically clarify no building, no grading, no lots on areas of 20%. So with that, can I see a show of hands who are in favor? John?
Well, you said no lots. Does that mean any lot that has any portion of it that's 20% is thrown out? I don't think you want to say that.
No grading.
No grading is the criteria. Right, sorry.
There will still be portions of lots that have 20% that can't be.
Thanks, John. Yeah, the criteria is grading.
And would the alternative then be to just uphold the hearings official and deny it, or are we just this condition?
Just this condition.
Okay.
Yeah. So all in favor of imposing a condition number 3 that reflects no grading on slopes 20% or greater, raise your hand.
Could I clarify? On page 24, are we voting on, does the PC agree with the staff and find that?
No, just look above that, Steve. You see that paragraph where it talks about condition of approval 3?
Right here.
As a result of our action last week,
Randy,
Where are we at?
which document are you referring to?
this is last week's AIS,
Just make sure.
page 24, right above the paragraph that talks about PC Action A. It talks about the very last line about recommended condition of approval number 3. That's where this condition number 3 came from. So by our 7-0 vote last week, we inserted condition 3. And all this is doing is reaffirming that action plus modifying it so that we strengthen and better clarify the understanding of what we have here. Anything else? Okay, then everyone supportive of that action, raise your hand. Opposed? Okay, so we have it as 7-0 reaffirmation of imposing a condition 3, and staff will work on language to clarify that for us. Steve?
Well, again, I think there's 2 issues here. One is whether we feel it's comfortable. Again, we've had this discussion before. We have all these conditions. Whether we feel comfortable imposing there's two questions here. One is, if we were going to impose conditions, this is the way we want it done. The other question is, some of us may feel uncomfortable imposing conditions. So I think we should frame it in terms of what we voted on was, if we were to impose conditions, these are the way we
And
like to
let me
see them.
ease your mind with that. When we get to the end of considering these other 3 or 4 appeal items, we have what would be a motion to either accept the conditions or, in the alternative, as staff has proposed, not to. So if we can defray that to the very ultimate end,
I
okay?
just wanted to clarify.
Appreciate that. Okay.
I mean, I think that the discussions that you've had make it pretty clear where you are, and I feel a little uncomfortable with the vote that you just took, because I want to just make sure you understand, and from your last question, I think you do, but really, I think right now, this is the condition that really imposes the big change in this development proposal, from 75 lots to lopping off everything that includes too significant a portion of 20% lot or 20% slope on it. You either are okay with that grand of condition or you're not. I mean, it's really, I appreciate what you're saying. It may be the culmination of all of them, but really this is the big one. And I think it might make sense for those of you, I just want to make sure you really know what you're doing. If you're not comfortable with the conditions, you probably, I want you to understand this is the moment that I think you want to express that. And I only say this because last time we got to the end of deliberations and kind of felt like that it wasn't altogether clear what was happening. So I just want to really make sure you.
Okay.
In other words, I think if commissioners feel that the condition would impose too great a change, we should be having that discussion now, not at the end.
John?
Well, I felt I was caught between a rock and a hard place. Certainly, we don't want to develop the 20% slope areas, so I can't vote against the motion. But I do think it's too significant a change to approve the project. So if we need to have that vote now, I think I know how it'll go. Let's have it.
Yeah, I mean, maybe there's two motions, and let's do them maybe right now. The first motion would be, you've already all voted in deciding that the criterion's not met, okay? Right? Because the criterion requires no grading on sloped areas, and the 75 lot plan certainly shows that. So now you're left to, okay, what are we going to do about it? Are we either going to impose a condition or are we going to deny? And so maybe understanding that you need to raise your hand in favor of one of the next two motions, it might be clearer to approach it that way. And if you don't want to do it this way, I understand, but I think it's clearer.
Well, yeah, Bill?
Well, I was going to be on a different topic and it got covered, but I would say I think that's probably a good way to go at this point. And if I'm understanding it right, then it would either be we're voting to move ahead with conditions or we're voting to deny.
And now that we know what the condition would be, let's go to page 16 of today's agenda. Steve?
I just wanted to note that while this is the primary focal point or whatever, obviously, like the solar lot standards, if we're voting on the 75 lot, then the solar lot standards aren't met, and so there are some other standards.
That's right.
This is sort of a surrogate for several other ones that, depending on how you vote, you're saying, well.
Yeah.
And we'll
Based
still want
on
you to
John's-
address each of those, and
Yeah,
if
but-
it's being
but-
presented
right.
as the 75 lot proposal. You may feel that conditions are appropriate on some of the other ones.
And this is based on John's request last time that staff has structured for us two alternative ways to go here. John?
Basically, what we're talking about is invoking cloture about whether or not we're moving forward with this project or not, or we're approving this project. So I think there's value in that because once we know whether we're moving forward or not, unless there's some substantive change that causes someone to change their mind, at least we get this discussion behind us because, frankly, it flavors all the other discussions. So I see value in that. Usually we wait till last, but I think, and there's some other areas where I might want to change a condition too. There are. But nonetheless, I think it provides clarity to this board as to where we stand. I think we know already. At least we will stop making our arguments to not approve the project.
John?
Yeah, I agree with the comment. This is a big one, but it has a substantial change on the site, which could, influence my thinking. How substantial is only somewhat clear by that supplemental illustrated map, but also taken in the context of collectively 18 conditions and each of those impacts, I think that also creates an issue. When I vote, I don't want to give the impression that I'm voting on a single issue making a determination, but it's definitely a major influence.
Other comments? Rick?
Yeah, I appreciate the conversation that's occurring. I'm somewhat concerned where it ultimately leads us on these types of decisions. If now we're going to actually be questioning conditions put on development projects as to how significant they are and what effect it is, it seems to me that our job is to make a decision if it's appropriate or not appropriate, or if we should condition it. And it's really the applicant to decide if they can meet all of these, or if it's too significant to make the project go forward. It hasn't been a practice in the past, and I'm not suggesting it can't become the new practice when we go through every one of these conditions and decide, is that significant enough for me to decide to deny it, or if I pick a group of 5 or 6 of them, is that enough to make me decide to deny? Because it's rare that we look at one of these types of applications that does not have 20 or more conditions attached to every one of them. I don't remember them hardly, other than maybe a small one or a little issue here. So I'm not sure where we're going with all of this. I guess I'm just trying to caution us to pay attention to that.
John?
And I guess, to me, is these conditions have changed this application enough that it's not an application that had a chance to be reviewed by the public.
Okay. Other comments? John?
I think I somewhat think part of our role is to take a look at the significance of those conditions, not necessarily the number. If someone comes in to build a bridge and we put 30 conditions on color, structure, this, facades, that's not the same thing as saying one of the conditions is you can only build it 2/3 of the way. That's a significant impact. So the point that I'm saying here is I think we do have something to say if we individually and then maybe collectively feel it's too significant of a change from the initial proposal.
Okay, well, let's see where we are, and just let's take this one slow and easy. Page 16 of today's PC agenda. In the highlighted yellow area, staff has presented 2 alternatives below the bullet there. And that first alternative that we'll take a vote on is that paragraph that begins, as a result of the above findings, the Planning Commission reverses the hearings official's decision, and the above condition of approval, also listed at the end of this final order as a condition of approval number 3, ensures compliance with the relevant approval criteria at EC 9.8325 sub 5. If this fails, then we'll consider the alternative, which is stated below it, which requires Planning Commission work on the reasons. Is that clear what we're voting on?
To either approve conditions or to uphold what the hearing official did in denial.
We are reversing the hearings official's decision and adding condition number 3. Okay, Steve?
I just want to clarify, the alternative doesn't really require us to do a lot of work. All we're going to saying is the 75-lot plan as submitted does not comply with the 20%.
Well, we will have to add reasons.
Pardon?
We will have to add
The
reasons.
reason is it doesn't
Okay.
apply. We don't have to non-condition a vote, from my point of view. In other words-
There's a blank there that would have to be completed.
Okay.
John?
Yeah, I said what I said because when I read the upper paragraph, it seems to be relating to a condition. When I read the alternative, it's relating to his whole decision to deny. The upper part doesn't say that with this condition, we're suggesting approval. And that's what got me.
This one condition in and of itself doesn't ensure that the project's approved.
Yeah, but the alternative is that we affirm his decision to
Right,
deny.
because it only takes one issue of noncompliance to render a denial, and this would be it.
Only one condition.
I mean, if there's one criterion that's not met, then you have no other choice but to deny the application. So if you say no here, that's it.
Okay.
Other questions, comments? Okay, then. Show of hands, all those who support reversing the HO's decision and adding condition 3, raise your hand. 1, 2, 3, 4 opposed, 4 to 3. Okay, so I guess we move on to the unresolved appeal issues.
Yeah, so moving to the next sort of remaining issue, it's appeal issues 3 and 7A concerning lot standards. In your packet, the highlighted language begins on page 21. And what we've done here is attempt to craft findings that address, one area where we felt that the hearings official erred, and that is that we believe he got the test wrong concerning the granting of a lot standards modification. The other has to do, I believe, following the last meeting with Planning Commission's concern that we address the full plan, the full 75-lot plan. And so we've added findings here which attempt to articulate that the eastern portion of the lot, that there wasn't sufficient evidence to warrant a lot standard exception on that portion of the lot. So basically, if you go to page 23, under PC decision, the effect of accepting these revised findings would be that the PC reverses the hearings official's basis for denial under this criterion and instead approves a modification to the lot standards for only the western part of the site. We would also be adding those findings with regard to the eastern portion of the site and essentially denying a modification for those lots. So, in other words, it would be, at the risk of oversimplifying, this would be another basis for denial of the eastern portion of the site.
Questions, comments for Gabe? John?
This is where I get back to, I want to make it clear, because it's referenced so many times. By doing these reversals, are we in effect approving the 47-lot illustrated plan, so that the applicant, whatever comes from today, the applicant just has to submit the 47 plan and it's a done deal? Is that what I'm understanding?
The way this is crafted and the way the findings are written, it really does rely on the 47-lot illustrative plan. Much like the prior discussion we had about condition number 3, if we want to pull back on some of that specificity, it's going to make our job that much more difficult to articulate which lots have an exception, which ones don't. I mean, there is some value in that specificity in pointing to the 47-lot illustrative plan. That's how we've crafted it here.
Bill?
Well, and I guess I want to ask again, this particular application is a tentative PUD, not the final PUD, and is there then another step in the process that gets into more detail, more refinement to address conditions or even evaluating things that might come up as far as slope in a particular specific area, those sorts of things?
Right. This is an application for a tentative PUD approval, and so there is a second step. It's a two-stage process. The second application is a Type 2 land use application. The main criteria for approval there is that it conforms to the tentative approval and all of the conditions attached to it.
And a Type 2 involves what?
It involves public notice. It's a planning director level decision, and then there's an opportunity for appeal and a hearing if parties disagree as to the planning director's decision.
Steve?
Again, I feel more comfortable if we don't cite the 47-lot plan, because there may be some slightly different ways to do it than what was, I mean, this 47-lot plan was put together some time ago, and it's not necessarily the best thought-out plan because, for example, it might be that they're going to drop off the eastern side based upon what we've decided so far. So, but still, even in this, there might be some layout changes that they could make which would, which wouldn't be a replica of the 47-lot plan. They might make some changes that would make solar lot standards higher in compliance because, but if we keep citing this as, now this is the golden standard, then we're doing ourselves a disservice. If we just say it meets these criteria, we will accept these conditions if it meets these criteria, and then they come back in their final plan and propose something. It may be close to 47, maybe it's 47 lots, but it may look quite a bit different. And that way we aren't suggesting that they just go with what they have, because it gives us the opportunity, if they can make improvements, they can do it.
I think Steve has an idea.
Well, we've heard that, I think, coming up in the previous discussion and now as well. I would say if there's general concurrence as we work through these, regardless of where your votes are right now, just if ultimately there are going to be conditions that deal with this change that happens, and you're more comfortable being more descriptive about it in a geographic sense than relating to the 47-lot illustration, we can make that kind of across-the-board accommodation. It was our thought that it provided more certainty for you to know exactly what we're talking about, to be able to relate to that. And yes, that would eliminate some flexibility, perhaps. If you're more comfortable with a little more flexibility, understanding geographically what we're talking about, fine, we can do that change. So maybe to help us through the next ones we're going to hit, which are going to also have that same reference, it might be simpler just to get a sense that that's where most of you are headed.
Yeah, I think you did hit it on the head, that has helped us focus the discussion, but Steve said it, and Rick has said it, and Bill has said it, and John has said it, it seems to tie it to that specific 47-lot plan, and that may or may not be the ultimate.
And if most of you are comfortable with that approach, why don't we just kind of assume that that will happen anywhere forward as we go through the conversation, that the 47-lot issues will be
We'll bring it up on
discussed
each one.
similarly. Right.
For the record.
Right.
Okay, other questions or comments? Okay, then what we're going to do is on PC Agenda Item 23, we'll take staff's first option here. It's at the top. The Planning Commission reverses the hearings official's basis for denial and instead approves a modification to the lot standards only on the western portion of the site, deleting reference to the illustrated 47-lot plan. Planning Commission also modifies the hearings official decision to add the above findings regarding the eastern portion of the site, and the Planning Commission therefore finds compliance with the applicable lot standards. Any final questions before I ask to see who's in support of that? Steve?
Well, again, I feel much more comfortable about this. First of all, again, as I said before, I'm looking at that site plan, and I can see some ways that you could improve solar lot standards. For example, that northern route could, which it does now, I think it does now, and the other one, it crosses the creek, right, in one spot, and, you could have another road that came off. In other words, you could reorganize the lots below it, too, so instead of going on a big facing east and west, there could be a side spur street that would allow them to be north-south as well. Because it seems to me that you could, without a lot of effort, improve the solar lot compliance standards on that site plan.
Okay. John?
No, I'm not there. I have questions elsewhere, but not here.
Okay, John?
This is John, sorry.
Maybe that you quickly know, on this basis, on the western side, how many lots are you approving modification of? Is it only the 26, 32, and 40? I'm a little... When all is said and done and you remove the eastern portion, how many lots are being allowed to be altered?
I'm not sure of the exact number. I know it's less than 10, but I don't think this reference on the bottom of page 24 21 includes all of the lots. There are three referenced there. Let's see.
Well, also, can you clarify, some of the...
The hearings official referenced 6 lots, and so that was, I mean, in terms of relating the appeal back to whether he erred or not, he was only granting an exception for lots, or was only considering the exception for lots 9, 10, 11, 26, 32, and 42, so.
Yeah, but I guess what I'm saying, although it won't be used, but if they submit number 47, how many of those lots have been altered to be less than the 4,500 for R1?
6.
6, okay.
Okay, other comments? Okay, then let's go to a vote. Then all of those who support the first option there, raise your hand. 1, 2, 3, 4, 5, 6, 7. Okay, so we have unanimous on that. Okay, so Gabe appeal issue number 4, applicants appeal issue 4 and sends appeal 7B, solar lot standards.
Okay. So, in a similar pattern here, we've attempted to address the solar, let's see, the solar lot standards, which the highlighting begins near the top of page 24 of the packet. And again, so we've gone through and tried to articulate findings based on evidence in the record about which ones are deserving of or meet the criteria for a solar lot exception, and also to add findings that the lots, that solar lot exception is not justified for lots on the eastern portion of the site. We've provided that rationale here, but again, the PC, as proposed with these findings, would be reversing the hearings official's decision regarding the western portion of the site to grant an exception, but not for the eastern portion.
Questions, comments for Gabe?
Can you clarify how many lots out of this subdivision now meet the solar lot standards? And, you know, what we're talking about on the eastern side.
Very few.
12 of the 47 down here.
On the western portion?
For the western portion.
Yep.
Right.
Bill's got
I
12,
think
bottom page.
Yeah, bottom of page 21 indicates 12 of the 47 lots
Yeah, there it is. Thank you.
Yeah,
lie outright.
I just, you know, this is one of my sticking points. We've dispersed with most of our solar lot standards, and pretty much the only place where it's really left is on R1 lots. I mean, you know, this is a standard that's there for the future, not for today. It's there for the future because we know as time goes on, we're going to be relying, you know, we suspect that we're going to be relying more and more on some of these issues, some of these energy sources. Even with gas fracking or whatever, that just extends things a little more. So, you know, other jurisdictions have been strengthening their solar lot standards. We keep weakening and weakening our solar lot standards. It seems to me, with some minor modifications, that layout could be redesigned so that a lot higher percentage of those lots would meet the solar lot standard. That's not the only way to take that western portion of the property. And obviously, you've got a couple of roads, but there's spur roads that you put in there that determine how you divide lots, and that could be done quite differently to get a much higher solar lot standard.
Rick?
Just I guess a question of staff, kind of along the same lines. When you look at a parcel like this, which obviously has a dedicated right-of-way snaking through it and so on, and you have to consider natural resources, connectivity, and all the other issues that come into play, is there sort of a hierarchy of who gets first choice? I mean, obviously, I would guess Goal 5 is right on up there. Obviously, the existing right-of-way has to be taken into account because you can't move that. So how does that type of process come into play? Is you try to go through all the parts and pieces and say, once we do all this, this is what's left for solar? Or, as Steve is asking, does solar kind of get to be one of the first configurations and you try to deal with connectivity later? Or And kind of give me that process?
There's no ranking system for this. They're all criteria that you look at, and of course, in the South Hills, balancing of all the objectives is always one of the difficult things. So you've got, in this case, you've got north-facing slope for the most part. You've got, wooded area, ravines, Goal 5 resources, street connectivity, streets in existence that you're working around. All those things are complicated, and that's always a difficult task with a lot of, especially with South Hills PUDs in particular. There is no answer to what's the right balance point. It's, that's what makes this difficult. So there's no hierarchy or ranking necessarily.
Other questions, comments? Okay, then let's look at page 25 of the PC agenda at the PC decision. And again, we'll take the first option, and that would involve the Planning Commission reversing the hearing official's decision regarding the western portion of the site and modifying the hearings official's decision to add the above findings regarding the eastern portion of the site. And I see no reference here to the 47 lot matter. Steve?
Well, the only thing, again, what I would suggest is we can reverse the decision, but we require that, some reasonable percentage of the lots meet, what's the normal standard? So isn't it 75%? I can't remember what the PUDs do. I believe it's 75%.
I think it's what it said.
So we just make a condition that 50% of the lots meet the solar lot standard, and let them figure out how to do it.
Tell you what we'll do is we'll act on the recommendation and then take that up as a suggestion afterwards, okay?
Instead of the 25%.
So any other questions or comments? Okay, then a show of hands from who support this option as stated. Raise your hand, please. 1, 2, 3, 4, 5. All opposed, raise your hand. 5-2. And Steve, you want to go ahead and toss your proposal out?
Well, again, it reverses the HO decision regarding the western portion of the site with the condition that 50% of the lots meet the solar lot standard.
50.
Well, the normal standard is 75%.
Okay, what are you suggesting?
50%, because right now it's 25.
Okay.
So I'm not saying that they have to meet the gold standard, what we normally comply. We're giving them some.
You're suggesting 50%. Okay, all in favor of Steve's proposals?
I would like to articulate a little bit of concern on staff's part that it's unclear to us what changes would occur or how the applicant would need to revise the configuration in order to deal that. So to provide that. In other words, we aren't sure if they could meet the 50% threshold that you're suggesting. And so in terms of feasibility, I have a little discomfort with this suggestion.
So do I.
Well, I can comment. I mean, you can imagine a bunch of spur cul-de-sacs that come off of the, in other words, right now, what you have mostly is all the lots are laid out on the main whatever you want to call these, the main throughways through the site. And there are other ways to lay it out where you basically send out some little spur streets that go east-west, so the lots can be oriented along cul-de-sacs, very, in this case, they may be very short cul-de-sacs. Obviously, it's a little more expensive because you're going to lay out some additional streets you didn't have to, but it's a way that you could reorient, a large portion of those lots so that they would be able to meet the solar lot standards. I mean, it's not impossible.
Okay.
And I don't think it's our responsibility to draw a design that meets it. I mean, I can look at that drawing. I mean, Bill knows I've been in this business for 40 years, and he can look at that drawing and see ways that it could be improved too. So it's not like, I don't think it's our responsibility to draw up a plan that meets the criteria. We just set what we consider as reasonable, conditions.
I think I agree with you. It's not your obligation. But you do have to ensure there's evidence in the record that shows a condition is feasible. And while I appreciate your expertise, I don't think, unlike, we have an illustration of the 47 lot proposal. It shows that it is feasible to meet with the condition to meet the 20% slope. I don't know that you have evidence in the record that shows it's feasible to meet a different standard for solar. So I guess based on what you're saying, the condition that you're proposing, I have some concern about as far as its defensibility.
Well, I think,
Let me go to Bill here, okay?
Well, and I guess my concern is, in looking at this specific site, we have an existing street snaking through a property. We have a largely north-facing slope, and we have Goal 5, we've got a lot of pre-existing constraints on this particular site that are going to affect how things are laid out. I mean, and, in an ideal world, you'd have a flat grid street with, south-facing lots, but we don't have that here because we've got topography, we've got all these other constraints. And I think to impose a percentage, whether it's the 25% that has been proposed here, I think we've got to decide if we're comfortable with the 25% instead of saying that we think they need to get 30% or 50% or whatever. And I think, to me, that's really the issue, rather than us getting into designing the project for them.
John Jaworski?
Yeah, this is where I get back to the same thing again. If we're supposed to put a condition on, I don't understand how we can, not being design engineers and not having, in all cases, an illustrated map supplied, know that it's really feasible. I would think that what we're saying is we think it's reasonable. Now, the reasonability can be on the basis that he's supposed to meet a minimum of 70. It's only 25. Something reasonable might be 50. And if that's a condition and he comes back and can't meet it under the Type 2 review, he could then be maybe granted an exception then. Is that not correct, or is it Type 2?
No, it's not correct. The final PUD process, the only criterion that's in play at that point is whether or not it conforms to the tentative approval and the conditions that are attached. An applicant can't elect to go back and attempt to readdress criteria that were reviewed in the tentative. The exceptions process here is really only afforded through the tentative approval. So this is the point at which they need to prove up. And it's not otherwise an adjustable standard. This is something that that needs to be addressed as part of the PUD to give them the kind of flexibility they're asking for.
Can't they come in under a final PUD submittal and also come in with an adjustment?
No.
Because
Wow.
there'd be a
I just
specific
had that
condition.
happen. Okay,
The
I'll go
specific
back to
condition
that.
would say you've got to meet 50%. They have to meet 50% to be in compliance with their tentative.
And if it creates a lot layout that is substantially different, then it doesn't substantially conform with a tentative.
It creates uncertainty with respect to the final, and it's deferring an unknown outcome to a later stage. And so I think that's the legal problem in terms of feasibility. We're not sure how or whether the applicant could comply with the condition, so we're uncomfortable establishing that type of condition.
Much like what the hearings official said about unknown changes that could occur if you went with the Matthews map, this is the similar kind of issue we're trying to illustrate is we don't know what the result would be. There may be other factors we're not aware of here, whether that's utility service or it's grades or other things that could come into play. Those unknowns concern us. To me, I think that the fundamental question, you're not obligated to do any other conditions here. You took a vote to determine whether or not you're willing to grant an exception as proposed, and that seemed to kind of indicate where you all stood. To kind of then think, if we could redo this project, where would we want it to be, is really not what's in front of you. It's really, did the hearings official err or not in this? And I don't think, well, it's up to you if you want to take a vote on this, but I'm not sure you need to feel any obligation to go to other steps beyond that. So,
Steve?
Yeah, I just wanted to make a note that the original proposal, something like 16% of the lots complied, solar lot standard, and then they dropped off, so now we have up to 25 without, really without much of a redesign. And again, I'm not tied to 50%. It could be 40%, it could be 35%, but the point is, it seems to me that, either we, I mean, most of our new stuff that we're adding in the city is either in the flatland in the north or it's in the in the hills in the south. So this is not a unique problem. And you can go and look at Ashland, and they have a similar situation where they're all, they're built in the hills and they faced east, they faced west. They have, other jurisdictions have much more aggressive solar lot standards, and they comply with them on R1 lots.
Okay.
And, it just seems to me that, by demonstrating feasibility, we've already shown that with a minor modification, they went from 16 to 25. So it seems to me reasonable to say that they could go some other step. I don't know what exactly it is.
Okay, well, what's on the floor, on the table is 50% compliance, so let's just see where we are with that. Those in favor of Steve's motion to require 50% compliance with the solar lot standards, raise your hand. Those opposed, raise your hand. It's defeated 2-5.
Should I try to propose 135, or is it not worth, going there?
I don't think so. Let's go on to appeal issue number 9, stormwater.
All right, so with stormwater, I believe we didn't get to an indication of as to how you all would vote at the last meeting, but in a similar fashion, we've attempted to go back and address the full 75-lot plan, clarify findings for the western portion versus the eastern portion, and essentially we tried to clarify what the difference was, that the hearings official wasn't really finding that compliance with the stormwater standards meant that they also complied with subsection 13, but that they were actually obligated through the condition to do something more in that they had to implement on-site detention, which gets at what we believe is the heart of the issue under the criterion 13 about the impact of increased flows and velocity within the stream corridor, and to protect against the damage from that. So anyway, with more detailed findings, we're basically recommending that you reject the neighborhood's arguments and essentially find that the hearings official did not err by correlating the detention requirements under 7J regarding increased peak flow or velocity as it relates to sub 13. So we've added the findings also to clarify that the eastern portion did not meet those standards.
And Gabe, before opening up for questions, suddenly in describing eliminating the 47-lot thing, it might, just for your consideration, be worthwhile to describe what you mean by eastern and western, and that might take care of the...
My hope would be is that if we can settle on some language around condition number 3 early on in the draft final order, that we can repeat that as we go through.
And I'm just
be consistent about
define eastern and western, not
Glossary almost.
yeah. And then you can just refer to those perhaps. Anyway, okay. Questions, comments about this particular item, John?
On page 2932, the first bullet talks about having each lot owner being responsible for maintaining a stormwater management system. Is that something that's been done before? My concern is that these tend to plug up over time. They have to be maintained. Usually my understanding is they're either in public ownership or in common ownership, not the dependence of the individual.
No, commonly they are required on a lot-by-lot basis. I mean, I think an example would be, like, say, a 2-lot partition, and the city's standards really clarify when, the applicant or future owners are obligated to maintain, and the city doesn't take on that maintenance costs and obligation. It's for the public stormwater system or shared facilities that are located in the right-of-way that the city would accept that responsibility. So it really is incumbent upon the future lot owner to make sure that it's maintained.
And that's a standard or a common procedure that's been required in the past?
Yes, for sites that require it.
Bill?
I'll just jump in. John, the apartments that we just built with our rainwater collection, it's all on our property and we're responsible for it.
Okay.
Steve?
Yeah, I could also reiterate from our neighborhood experience, all the multifamily apartment projects have to basically deal with their own stormwater filtering systems.
It's
You know,
an
sometimes
interesting discussion, but not on the record, so I wouldn't want you to
Okay,
move on.
thank you.
with that.
I withdraw it.
that was not my concern.
Oh.
My only other concern was in terms of imposing conditions. We've talked primarily about the individual lots. There's some, there's the public streets, but there's some private ways and so forth. I assume that they'll be paved, and I don't know how the stormwater is being treated with those. Is that being put into a stormwater system? And my main concern is we may need to add some additional conditions, drainage swales or whatever, depending on how they deal with these other places, so that they are also taken care of, that's all.
Well, and I believe that the code standards and the conditions that we have embedded here will take care of that.
I just wanted to make sure it was put down here so it wasn't like,
It's not an issue that's addressed under this appeal argument, so I don't think we can go there, but I would just want to reassure you that through our public improvement design standards and the private street standards, that we will thoroughly address the stormwater standards.
well, it says that the imposed flow control standard was at EC 98325. Is that just specifically per lot?
Well, the condition of approval requiring on-site detention on a lot-by-lot basis is really specific to the lots themselves, not the street system. But there are other standards that will come into play that they'll have to adhere to.
Other questions or comments? Okay, then let's go to page 34. The first option is that the Planning Commission finds that the hearings official did err in not addressing the eastern drainage basin. The Planning Commission modifies the hearings official's decision and establishes a condition that the eastern portion of the site be removed. So all in favor of supporting that conclusion, raise your hand. 1, 2, 3, 4, okay, 7-0. And that takes us to Senate Appeal number 11, the 19-lot rule, transportation.
So here, when looking at this question of western versus eastern portions of the site, we found that it really made no difference, that the hearings official's interpretation was correct in finding compliance with the 19-lot rule, and that doesn't really change if you take the eastern portion out. In other words, through the connection of West Amazon Drive at both ends and 2 points of dispersion, we think he was correct in finding that they met the rule.
Questions, comments for Gabe? Steve? Okay. Then let's go to page 36. First option is that the Planning Commission agrees that the hearings official did not err in finding compliance with the above approval criteria, but Planning Commission modifies the hearings official decision to add a finding that even if the eastern portion of the development were to remain, it would not cause a violation of the 19-lot rule. All in support of that option, Steve?
Well, since we've already lopped out the 19-lot, the eastern portion, couldn't we just say that, just to make it cleaner, just get rid of the...
To respond.
it's just a suggestion. It's not crucial.
I'd leave it.
We were just trying to be complete in answering the question.
Just to be thorough, we've added the finding that really, we don't think he erred, and that doesn't change with or without the eastern portion.
Okay, that's fine.
All those then in favor of supporting option 1, raise your hand. 2, 3, 4. Okay, 7-0. Okay. So that takes us down to the overall recommendation. John?
I got a couple of minor points I'd like to quickly speak to, if I may.
Sure.
On page 18,
That's PC agenda, page 18.
yes. First line about using a circle rather than a square. Am I in the right place? It says
Yep.
PC concludes a circular tool does not produce more accurate measurements than a square one.
Yep.
It does. I think it was used sufficiently here, but the problem is, you see, is you have to compare the space between two lines. Those two lines may not be parallel. It becomes very difficult to apply a square tool. You can only have it parallel to one side or the other. I would just like to remove that phrase if we could, because it's not geometrically accurate. I'm comfortable with the phrase in the line of page above that says the circular measurement did not provide different results. But that's because I trust that it was accurately used to try to negate the problems with using a square tool. But frankly, I'm sorry, I was a GIS person. A circular tool is far better than a square tool in this respect, and I think we should take that out of this document.
So it would be that whole first sentence on,
Let's see.
I heard differently from Randy.
I just reversed it, say, does provide more accurate measurements.
Based on the discussion last time, I thought we heard a majority of you felt that it was important to clarify that the square was an adequate basis because it was what was used with the staff analysis and on the
yeah,
application.
that's different.
Adequate.
I think it's adequate, but it isn't more accurate.
Okay,
That's the
just
paragraph.
to clarify.
Paragraph before says that.
I would agree with that.
Okay.
The square
Wanna
is
make sure.
accurate, or adequate, but the circles,
And hopefully we'll require a circle in the future. Okay, the other one
I'd be
is
inclined to use that.
circle?
Yeah.
Yeah.
So to clarify, we're striking the sentence?
Unless you think it makes a difference in the results.
Either strike the sentence or just change the, from positive to negative. So it does produce more accurate
Then
measurements.
it creates problems, I think, if you say it does.
Yeah,
I think it's cleaner if we just strike it.
Okay, thank you. Then on page 22, in the list of arguments as to why, let me get there. PC 22, yes. You have a series of findings here as to why this condition is met. Number 2 says that a compatible mix of land use that encourages alternatives to the use of automobiles, and the fact that there are pedestrian connections to the adjacent parklands is sufficient to make this point. What percentage of the automobile trips these people would make would be to drive to go to the parklands? It strikes me as a bit specious. So I would suggest removing it because it really doesn't significantly impact the use of the automobiles by these residents.
now, say that where we at again, John?
Number 2 on the top of page
Oh,
22.
okay.
I'm sorry, I didn't say that.
And just to be clear, from a code standpoint, we don't need to make findings on every single basis for the
Exactly.
with regard to the purpose statements, so it wouldn't affect the outcome if we were to strike that one finding.
Any objections, folks? Okay.
And then number 3, I have difficulty with as well, which says that smaller lots result in cheaper houses. I don't think that's true. We just have a larger percentage of coverage with the same size house and a smaller lot. So I think that one's a weak argument as well, and I'd like to remove it.
Any objections?
Not for this site.
Okay.
I know they're minor points, but I just want to,
Bill's
Oh,
pondering.
I'm pondering.
These are north-facing view lots, right?
Yeah,
Yeah.
yeah.
These are
The
not.
location's probably going to affect the price more
Yeah,
than,
I would think so.
I'm okay with that.
Okay.
so, thank you.
That it, John?
Yes.
Other questions, comments? Okay, I think Bill has then a motion to make.
Okay. I move that the Eugene Planning Commission finds that the subject application for Deerbrook PUD, PDT 12-1, meets all applicable PUD approval criteria from EC 9.8325, with additional findings and conditions of approval as described above. The hearing official's initial decision to deny the application is therefore reversed.
Is there a second? Second. Rick seconds. Discussion? Okay, all those in favor of the motion, raise your hand. 1, 2, 3, 4. You're up, John? Is your hand up?
I'm up to, what are you voting on? You're voting
whole
that?
thing.
Oh, you don't, you're rechanging this whole issue here versus to what was given by the vice chair?
He's voting on the whole.
The motion is to reverse the hearings official's decision and to impose with the findings and the conditions of approval that we've just gone through and discussed.
Approve the project.
Okay.
Yeah.
Are you clear now? Okay. All in favor of the motion, raise your hand. 1, 2, 3, 4. All opposed, raise your hand. It carries 4-3.
So it's just a point of process. With these changes, staff will work on a final decision that will actually come back to review before signature. So all of you will need to review that, and there will be a final vote at the next meeting.
And we plan on that the 17th.
We can do that first thing on the 17th. That'll be in the slope room.
That'll be in the slope room. First thing on the agenda on our 17th meeting.
And between now and then, I can't say exactly when, we will present you with the final version of the final order in advance of the meeting, so you have a chance to read it before we...
That would be nice. Yeah. Okay.
You'll get to see it.
Okay, moving on to item 3, items from commission and staff. Staff, any items? Commission members? John?
Do the doodle poll. Those of you who haven't.
Doodle poll for the retreat.
We'll meet again tomorrow evening, 6 o'clock, public hearing, the slope room.
Yes.
Public hearing on the downtown nodal overlay and the farm animal. Rick?
We're expecting a small turnout for that. The slope room is rather snug.
We've asked other staff that are closer to this, and we think we'll be okay. We're doing our best, but we also are needing to move to the slope room as well.
Steve?
Just a question on access. Is the main atrium open to get into the stadium? Sorry, on question.
Yes, we'll leave the doors open after hours, if that's what you're asking.
Yeah, I didn't know. I want to know just which door to go to.
Could be both ends, either side of the building should be open, yeah.
Rick?
I guess I'd like to take this opportunity, just in case we don't see legal counsel again, that I've greatly enjoyed working with you over the years, and I will get you for what you did.
Thank you.
You stay on and you leave. We're going to miss you a lot. You've been a great help. You're a great resource. Really greatly appreciate your insights. This helps us a lot. Do we know who your replacement will be at this time?
No. No, I gave a couple months' notice. I'll be here through January 18th, but I don't actually know if I'll be with you again. It depends. I'm shifting all my efforts to the Envision Eugene project. So this is sort of my last application that I'm working with you on. And certainly I'll still live here, and I'll still be advising local governments, and our paths will certainly cross, I'm sure. And I've greatly enjoyed my experiences around this table.
And since you've worked so closely on these and some other ones that are still sort of moving their way through the state processes, will you be back to help us with those?
I just want to wish you good luck.
I
think that's a no.
We only thank
I think there are several lawyers involved in this one, and I would probably be backing out anyway, so.
Thank you for your service, all your advice, and consider applying for the LUBA position, will you?
Yeah, there you go.
Very welcome.
Can I add, thank you for your patience, your tact, and your grace in dealing with us on many matters.
Thank you. You're welcome.
I think Bill has an emotion to reject your,
Yeah, I emote that we reject her.
I second.
Impose a 10-year
I think
requirement.
there's no discussion on that one, right?
anything else from the commission? All right, folks, thanks very much. Meeting's adjourned.